Today's episodes of your favorite ABC soaps will be seen tomorrow. Now this ABC News special report. This is an ABC News special report.
Good afternoon, everyone. I'm Peter Jennings at ABC News headquarters. This is a very important afternoon in the political life of the country, and we've interrupted regular programming to watch and hear arguments to the Florida Supreme Court on the fairness of the presidential election process in Florida. There's always a certain majesty in having access to the courts, especially on fight day. And as the whole country knows, Florida is the scene of a war between the presidential campaigns. The 7 justices who will be in the courtroom shortly are being asked to settle very intense, crucial arguments. Under what circumstances should counting ballots by hand be done? As you know, Florida counties have been confused about this. Much more importantly, the court has been asked to decide whether the results of these manual hand counts should be included in the final Florida tally. Secretary of State for Florida said last week that Florida counties had to count and certify their votes by deadline on Tuesday night or have a very good reason why they needed extra time. And when the deadline came and went, she said the counties had not given her reason to extend the time, and therefore any additional votes would not count. Here's what she said at the time.
I've decided it is my duty under Florida law to exercise my discretion in denying these requested amendments. The reasons given in their requests are insufficient to warrant waiver of the unambiguous filing deadline imposed by the Florida legislature.
Well, the Gore campaign in 2 of Florida's counties sued her immediately, but her decision was upheld in circuit court. And the clerk of the court read the very succinct decision from the judge.
On the limited evidence presented, it appears that the Secretary has exercised her reasoned judgment to determine what relevant factors and criteria should be considered, applied them to the facts and circumstances pertinent to the individual counties involved, and made her decision. My order requires nothing more. Accordingly, it is ordered and adjudged that the plaintiff's motion is denied.
Well, no sooner had that occurred than the Gore campaign appealed the decision to the state Supreme Court, which is where we are this afternoon.
Florida Supreme Court in Tallahassee today. Lawyers for Vice President Gore argued for including hand recounts in new final tallies. Governor Bush's lawyers argue the opposite. Meanwhile, a lower court judge refused to order a new election in Palm Beach County because of allegations the ballot was confusing, and hand recounts continued in Palm Beach and Broward counties, while Miami-Dade County began its hand tally. Statewide, Governor Bush continues to lead Vice President Gore by 930 votes after absentee ballots were tabulated over the weekend. We go now to extended excerpts from the state Supreme Court proceedings this afternoon. Betty Ann Bowser reports.
The Florida Supreme Court convened at 2 p.m. Eastern Time in Tallahassee.
Hear ye, hear ye, hear ye! The Supreme Court of the great state of Florida is now in session.
Of the 7 justices on the High Court, 6 were appointed by Democratic governors. 1 was jointly appointed by a Democratic governor who died in office, then approved by Governor-elect Jeb Bush, who followed him. Before the court today were several key questions, including when and how should manual recounts be done? Should Florida election officials wait until the hand counts are completed before certifying the final tally? And did Secretary of State Katherine Harris use proper discretion in attempting to enforce a deadline for submission of all vote counts 7 days after the election? Each side had 1 hour to make its argument. Chief Justice Charley Wells began by taking note of the significance of the occasion.
Good afternoon, ladies and gentlemen, and welcome to the Florida Supreme Court. The court is certainly aware of the historic nature of this session and is aware that this is a matter of utmost and vital importance to our nation, our state, in our world.
First to be heard was Democratic Attorney Paul Hancock on behalf of the Florida Attorney General. He was asked by Chief Justice Wells what the impact would be of certifying late returns from the hand count.
The question really revolves around amended certifications. Now, my question is specifically, what is the Attorney General's position as to the date in December that the Florida's electoral votes would be prejudiced or not counted in the Electoral College if there is not a certification by the Department of State under 103.011? What's the date, the outside date that we're looking at in which puts Florida's votes in jeopardy?
December 12th, Your Honor, is my understanding. The Electoral College meets on December 18th. The issue, and we have constitutional law professors here who can address this, but my understanding is it's December 12th.
Okay, now if it's December 12th, under Title III of the U.S. Code, in that Section 5, it seems to indicate that in order for that that 6-day provision to have meaning, that all contests and controversies concerning the state votes must be resolved in order for the state's resolution to be final. Now, would you fit that provision of the federal statute into the Florida provision so that we would have some guidance on what is really the prejudice?
Well, we don't know what contest will arise. I think what this points to is the importance of this court using the full reach of its authority to establish procedures that ensure that this results in a process that, first of all, is fair, that is perceived as fair to the world, and in fact is fair, that it counts the vote of all people who attempted to exercise that vote.
Vice President Gore's attorney, David Boyd, was asked how to avoid placing Florida's 25 electoral votes at risk.
How is it going to work within that time period for the votes to get totally recounted, and then if Governor Bush wants to contest that, for him to get a contest finally resolved? Or isn't it, I'll pose my whole question, isn't it something that the Secretary of State, as the person who has to do the certification, should separate out those that aren't uncontested on both sides, and then with the ones in the middle, there would have to be a determination made in the final certification as to whether there was you could get that finally determined or not, and how many votes you're talking about, and whether those votes in the middle would actually cause the election to be different. Do you get my drift?
I do, Your Honor, and I think I agree with maybe one exception, and that is the court talked about the Secretary of State dealing with the votes in the middle. I think that under Florida law, those are first counted by the county canvassing boards, and then there is a judicial question as to whether those votes have been properly counted, but that is not a question for the Secretary of State. I also think that this court certainly has the power to say, what we're going to do is tell the county boards that you've got this amount of time to complete your recount. And at that point, those votes are then subject to being contested by Governor Bush or Vice President Gore. And those contests then take place in a time frame that allows everything to be completed by December 12th. So I think it is clearly within the power of this court to say, in order to meet the date of December 12th, you've got to have all of your votes manually counted that are going to be included in this initial certification by a particular date, and then the contest, if there is one, takes place between that date and December 18th.
Do we have information in the record that can guide us? Do we know how long it's going to take to do these things? Or are we just going to reach up from some inspiration and put it down in paper?
Your Honor, I think it is in between. I think there's some information in the record, but to be completely candid with the court, I believe that there is going to have to be a lot of judgment applied by the court as well.
Why shouldn't the Secretary of State be the person to set a date instead of a court? Why couldn't the Secretary say that this is the time frame that I need in order to fulfill my duty of getting the certification in and set an arbitrary date?
But Your Honor, the Secretary of State's function is a ministerial function. She is not going to be the person who presides over the contest. The contest, if there is one, is going to be a contest that is going to be before the circuit court and ultimately before this court.
However, Mr. Boyce, that brings us to the may ignore language in that statute. And wouldn't you have to agree that the may ignore does connote some degree of discretion? And why isn't that discretion set on the basis of that she may ignore them if if the acceptance of the amended certification would prejudice the other voters whose votes would be certified because they were already there and get timely counted in the Electoral College?
I think, Your Honor, you could say, and this is not that different from what we have argued, that as long as the manual recounts will not impair the final certification in time to permit the selection of electors by December 12th, that those manual recounts must be included. That is, the Secretary of State's discretion, to the extent that she has any, would be discretion to say, I need to have the results by this particular date in order to be sure that the results are included by December 12th.
Well, you keep referring to it as a ministerial act, but under 103.011, doesn't the Secretary have a duty to protect Florida's electoral votes by getting the certification made?
Yes, Your Honor. And what I meant to be saying was that in order to get that certification made, she needs to have enough time to make that certification. But the fact that the certification is a ministerial act doesn't mean it's not important. It simply means that it's an act that, in our view, can be done relatively quickly, that she doesn't need 5 or 10 days to do it.
Please be